Thank you. Good morning. It's great to be here with my colleague Holly Mitchell as we announce a series of bills that seek to stop the school to prison pipeline and keep young people from our prison system. We are here to talk about young people's future, and I couldn't think of a better place than Leah Tata Floyd Elementary, which Senator Mitchell will give us more details on why we specifically picked this location. We have made major progress in California toward fairness, but in some parts of our juvenile system, we are still stuck in the past. In California, 1 in 22 black men is imprisoned. African Americans' rate of imprisonment is nearly 9 times that of whites. Latinos' rate of imprisonment is nearly 2 times of that of whites. Black and Latinos are more than 70% of our prison population, but less than half of the state's population. The first bill I want to talk about is SB 395. Almost 50 years ago, on May 15, 1967, the U.S. Supreme Court decided that Miranda rulings included young people accused of crime. We are kicking off a 2-month celebration of the ruling by introducing SB 395. SB 395 reflects 50 years of research into how children really think, really learn, and how they act. SB 395 requires an attorney to be present during a police interrogation before a child waives his or her Miranda rights. California's law on police interrogations of juveniles has not changed in half a century. Under existing law, children, no matter how young, can be interrogated by police and deemed to have understood and waived their rights without any special child-appropriate explanation. For example, California courts recently held a 10-year-old legally waived his rights, even though he told the police that he thought the right to remain silent meant that he had the right to be calm. Young people who are interrogated without an attorney are much more likely to confess to a crime they did not commit. A recent study of exonerations found that 13% of adults had falsely confessed, compared to 42% of juveniles. That's a parent's nightmare, if you can imagine. Their child confessing to a crime they did not commit. It is also a nightmare for the police who are seeking the real perpetrator. False confessions hurt everyone. We have learned a lot about young people's brain in the past 50 years. Young people learn differently from adults. They make decisions differently, and they need a different approach in our laws. California law on this issue is old, and it doesn't reflect the dramatic changes in scientific understanding about the ability of children and youth to understand complicated legal issues. Most youth can understand their rights and what the waiver means, but what is needed is to help them understand is the difference than what adults actually need. Every county already has a system to provide attorneys to youth and people who cannot afford an attorney. This bill would rely on existing systems of representation. It makes complete sense to offer and give students that opportunity to really understand their Miranda rights, and they only could do that with an attorney present. The next bill I want to highlight is SB 394. We also need to update our laws for young people who have committed crimes. The U.S. Supreme Court recently held that life without parole is an unconstitutional penalty in nearly every case in which the individual was under 18 at the time of the crime. SB 394 would bring California into compliance with the U.S. Supreme Court's decision on this issue. SB 394 will mean that a youth would serve a minimum of 25 years, ensuring that they are punished for their crimes and they have an opportunity for release. California may comply with the Supreme Court's constitutional mandate by offering parole consideration to youth offenders serving life without parole instead of conducting resentencing hearings. California is one of the worst in the nation when it comes to racial disparity of sentencing youth without parole. Black youth are sentenced to life without parole at 18 times the rate of white youth. Latino youth are sentenced to life without parole at 5 times the rate of white youth. Youth life without parole does not reflect the well-established scientific understandings about adolescent brain development. The research and common sense reflect the reality that youth are different from adults. The California law that requires life without parole for youth in certain cases was passed more than 20 years ago. At the time, we didn't know what we know now about adolescent development. We know that youth are still developing into their early 20s. They are different from adults in that they have special capacity to change. All the research into children's brains development says that we need to move away from treating young people as adults. We need a greater emphasis on prevention, rehabilitation, and maintaining family cohesion. At this time, I'd like to turn the microphone to my colleague, my good friend from Los Angeles, Senator Holly Mitchell.
Thank you, Senator Lara, and I'd like to thank you actually for being the brainchild, for approaching me about introducing this package as a partnership. So I want to thank you for being my partner in equity and justice. That's very meaningful and very important for a variety of reasons. We'd like to thank Principal Eric Chapman here. This school is a perfect, I think, kind of model of what we're working together around equity and justice. They have MESA, the after-school program. I first came to this school 2 years ago as a result of their partnership with the Robertson Family Development Center and the fact that they offer freedom schools here. And freedom schools are a project of the Children's Defense Fund where during the summer young people are encouraged to read through reading about their own cultural experience and history. And they invite adults from the community to come and engage in what they call Harambe, which is the morning greeting, and to read a book. So I first came to this fabulous school 2 years ago to read a book, saw this incredible mural, and when my partner said that he thought it was important that we ground this package and launch this package at a school, I thought about this place, so we thank you all for being here. About 10 years ago, I think my own personal foundation was shaken when I first was introduced to Marian Wright Edelman, the founder of the Children's Defense Fund, and saw this book that I think really coined the phrase cradle to prison pipeline. And the book is America's Cradle to Prison Pipeline. And for me, a picture speaks 1,000 words. And it's a very young man, maybe 7 or 8, who is so small, he is standing on a milk crate so this law enforcement officer can fingerprint him. And the book is filled with statistics that, quite frankly, Senator Lara, remain true today, have probably gotten worse in terms of the role poverty plays in leading to the cradle to prison pipeline. The disproportionate number of young Latino men, young African American men, and now growing numbers of young women of color are caught up in this cradle to prison pipeline. And so 10 years of nationwide data and research, and we still are at a place where we're forced or encouraged to introduce this equity and justice package of bills. We want to thank the Youth Justice Coalition, Western Center, a number of fellow equity and justice colleagues for being with us today to launch this package and talk about the fundamental meaning of equity and justice. In the package, I've contributed 2 bills, the first being Senate Bill 190, which will end juvenile court fees. Again, our goal of being here today is to advocate for the future of California. And we know that future is dependent on providing all children the opportunity to thrive. Specifically, SB 190 will help the most vulnerable children by ending the juvenile administrative fees charged to families when their child is held in a youth detention or youth probation facility. These fees can quickly add up to thousands of dollars and disproportionately impact families of color. Understand, children don't get to bail out. If a young person is arrested and they go to juvenile hall, they stay there until their court date. Their court date may ultimately conclude that they were innocent. So they've been held in juvenile hall because your parents can't bail you out. The bail system doesn't apply to kids under 18. And then I get a bill charging me for holding my child in juvenile hall when he or she may have indeed been deemed innocent in the first place. Administrative fees undermine the rehabilitative goals of the juvenile justice system by straining family relations and harming familial economic stability. Furthermore, the research finds that counties often assess fees that are not authorized by state statute. Ultimately, counties obtain minimal returns despite the high fiscal and societal costs with collecting the fees. Might I add, the high administrative costs the counties bear to collect fees that don't match the costs they've exerted to try to collect them. The second bill is SB 439, which will set a minimum age for juvenile court jurisdiction. This would exclude children 11 years or older, or younger, from detention and detainment or even prosecution through the juvenile courts. Over 70% of cases that are referred are children of color, exposing them again to the cradle to prison pipeline. Youth under 12, as Senator Lara already talked about, are inherently less culpable under criminal law given their expected developmental immaturity. All of us who are parents and all of us who are honest enough with ourselves to remember our own developmental stages under 12 should fundamentally understand that jail is no place for a child under 11. As Senator Lara said, children have, we say diminished capacity, but I don't know that that's fair. Children are not pint-sized adults. They have a developmental process that they go through to grow into adults. So for us to expect that a child would have the same judgment, understanding of legal terminology, is simply naive on the part of adults, quite frankly. Evidence shows that formal justice system involvement has a negative psychological impact on children. Alternative services through the child welfare services system exist outside of the juvenile justice system that are more beneficial for the child, public safety, and for society as a whole. These alternative services provide children the help necessary to overcome negative circumstances in their life, thereby giving them access to the resources they need to be productive, contributing residents of our state. We thank you for being here today. We thank all of our partners who've joined with us to launch this very critical, relevant, timely package to make sure that we put California's children first on everyone's agenda.
Thank you. We'll now open it up for questions. All right, go ahead.
Hi, Capital Public Radio. I was just going to ask a follow-up to both of you. As far as SB 439, what level of support do you have from law enforcement? What are you hearing from them on this?
Yeah.
Well, today we're launching, so I'm sure we'll have plenty of opportunity to hear from all of our partners, law enforcement, educators, everyone, who will begin to weigh in. The bills are out new. I personally have not heard yet from law enforcement. They'll be heard in policy committee starting this week, and that's when we'll begin the important dialogue about what's best for California's children. Again, from my perspective, the research suggests that, and in many instances, research that has been grounded here in California. California was the innovator on all the 0 to 5 brain development research. And so it seems to me research that we've championed nationwide and funded through our Prop 10 commissions, we ought to adhere to and pay attention to. And so we're clear about early childhood development and how that goes up into the early 20s. And so we're ready to have a productive, fact-based conversation with law enforcement about what's best for young children.
I think it's also important to note that in looking at our conversations with law enforcement is we want them to do their job more effectively, but we also need to look at those policies that are in statute that treat certain children much more unfairly than others. And so I think that's our job, and as we dialogue with our law enforcement counterparts, is to hone in that message that we want to make sure that everybody's treated fairly under the law. Clearly, black and brown children aren't, and we as policymakers need to do what we need to do in terms of changing the policies to ensure that every child, there's equity in the system for every child. The numbers do not lie. They're stark and telling about who are the ones that are most affected with the current policies that we have in place, and those are brown and black children.
Please quantify on several of them. What exactly as far as the number of kids under 11 that are incarcerated, if you know, and the number of, I think we've already got the life off the roll. It's a practice even if it's not in law. Is that still going on?
Do you want to do the...
I don't know the number of children currently being detained in juvenile justice facilities. We've heard stories from chief probation officers, some of the national statistics in this book, again, that are 10 years old, that talk about the practice of young children being detained. We don't have those specific numbers yet, but as we go through the process, this bill will be first heard in Public Safety Committee April 4th. That's the kind of data we'll be gathering between now and then. Thank you very much for that question. And, you know, let's be clear. It's not, we are not naive. We know that there are children who have engaged in and been involved in, you know, heinous crimes. Our point is acknowledging the circumstances that led them to that point in their lives and really figuring out the best placement to provide them with the appropriate support. So we're not questioning or challenging whether or not public safety should trump their development. We are suggesting that they should be dealt with in the child welfare services kind of side of the house, where we have group homes, we have settings where they can be held, but it's not jail. It's not incarceration. It would be age appropriate housing, treatment, and services. And so that's the goal of 439.
Any additional questions?
As far as the fees, can you address as far as how often that happens? I think you said thousands of dollars. Can you explain a little more how this goes along with this, how often?
And so there are some counties that don't collect the fees, and yet there are counties who do. So it's inconsistent across the state. Our goal with 190 is to make a blanket statewide policy ending the collection of juvenile fees. And so it varies county to county. We have someone here today, I understand, who was charged a fee, and perhaps after we adjourn, they can tell you their personal story. We've heard stories in Alameda who has since stopped the practice. And so it varies across the state. The point of this bill is to end it and create a statewide consistency of no more juvenile fees charged.